Hi, today we'll begin with Chapter 1 on patent law. This chapter lays the foundation for understanding what patents are, why they exist, and how they shape innovation and society. Think of it as the starting point to grasping intellectual property rights. What is a patent? A patent is like a deal between the inventor and society. The inventor gets an exclusive right to make, use, or sell the invention for a limited time. In return, they must disclose the details publicly so that others can learn and build upon it. So it's both a reward for innovation and a tool to spread knowledge. Objectives of patent law. The key objectives are simple: encourage innovation, protect inventors, and at the same time, make new technology accessible to the public. Patent law is always about balance. If inventors don't feel secure, they won't innovate. But if protection is too strong, society loses out on access. The law tries to walk that fine line. Types of patents. There are three main types of patents. Utility patents cover functional inventions, machines, processes, or chemical compositions. Design patents focus on aesthetics, how something looks, not how it works. And plant patents are for new plant varieties developed by scientists or breeders. Together, these categories cover both science and creativity. Criteria for patentability. Not everything can be patented. An invention must be new. That's novelty. It must also be non-obvious, meaning a skilled person in the field shouldn't immediately think of it. And it must have utility, something useful in industry or daily life. Finally, it can't be something excluded by law, like natural laws or abstract ideas. This ensures patents protect genuine innovation, not basic truths of nature. Rights of a patentee. Once granted, a patent gives powerful rights. The inventor can make, use, sell, license, or assign the invention. More importantly, they can prevent others from doing so without permission. That means they can also earn royalties or profits by licensing the technology. But remember, these rights are territorial, meaning they apply only in the country where the patent is granted. Limitations and exceptions. Patent rights are not absolute. Governments may allow compulsory licensing. For example, to make life-saving drugs affordable during a health crisis. There are also research exemptions so scientists can study without fear of infringement. And of course, the rights don't last forever, usually just 20 years. After that, the invention belongs to the public domain, free for everyone to use. Patent procedure. Getting a patent isn't automatic. It's a detailed process. First, the inventor files an application. Then, the patent office examines it for novelty and inventive step. If it passes, it's published, and finally, a patent may be granted. But enforcement, that is, stopping infringement, is the responsibility of the patentee, often through courts. So, patents give rights, but they also demand effort to protect them. International dimensions. Innovation is global, so patents can't stay limited to one country. That's why we have international agreements. TRIPS under the WTO sets minimum global standards. The Paris Convention allows inventors to claim priority across member countries. And the PCT, the Patent Cooperation Treaty, simplifies filing in multiple countries with one international application. These frameworks make it easier for inventors to protect their work worldwide. Conclusion. So, to conclude, patent law is not just about rewarding inventors. It's about creating a system where innovation thrives while ensuring that society benefits in the long run. It's a balance of rights and responsibilities. With this foundation, we'll be ready to dive deeper into infringement, licensing, and practical case studies in later chapters.